Okay, folks, well, on the agenda, you'll see we have a pretty busy day. We're talking about vaccination rollout, SEMA's pending PERB charge, telework policy, victory over at the court with PERB, actually, regarding a demotion over there. We'll be talking about some GARE and Real Teams discussion, an update on our third rep, and then OE3 election results. So why don't I go ahead and start with the vaccine rollout and the PERB charge, Zeb, then you can take over telework. Sound good?
Sounds great.
Great. So I think folks will have seen from the updates, right, that as of last week, SEMA filed a PERB charge against Santa Clara County. Give just a bit of quick background on this, what that means. So PERB is the Public Employees Relations Board. They govern the relationship between public sector unions and the employers in California. And in some sense, they have jurisdiction over questions and disputes about whether there's been violations of MMBA. MMBA is the Myers-Milius-Brown Act, right? So SEMA filed a PERB charge against Santa Clara, not in an attempt to stop the vaccine rollout, per se, not to stop the question of whether or not there's going to be a vaccine mandate, right? The courts have already made it clear that employers do have the authority to implement vaccine mandate policies, even when it was solely an EUA authorized vaccine. They do have that authority. However, PERB gave clear direction several weeks ago, it's about a month ago now. There was a PERB case between UC Regents and some of their employees of the UC system. And what PERB ruled in that case is that employers, while they're not obligated to bargain whether or not there is a vaccine mandate, they are obligated to bargain impacts and effects of such a vaccine mandate policy. So this is kind of the same threshold that we look at, for example, when it's not an issue that directly affects, you know, wages, for example. The county can't just unilaterally change wages, right? That requires a full scope of bargaining if they wanted to change wages, and moreover, the contract need to be open, right? However, when there's smaller scale changes, you don't have, you know, full duty to bargain, but you'll have something lower, for example, referred to as duty to bargain effects. So what are effects in this case? Effects could be things like what happens to folks who are non-compliant with the policy? What are the impacts going to be on departments? What are we doing to mitigate the potential loss of staff? You know, how are SEMA managers and folks in charge of implementing this policy going to be responsible for that? Who's going to be handling all that work? You know, what's the scope of exemptions? Is there anything that's pre-approved? All those kind of things, right? And that's the process that the county didn't engage in with SEMA or any of the other unions in the county in good faith. You know, we saw this hit the news media several weeks before it actually was rolled out. We saw first Dr. Smith and then James Williams saying there was going to be a vaccine mandate. You know, in good faith, SEMA was reaching out prior to the policy being implemented after those news articles saying, hey, SEMA would like to meet. We're happy to discuss a policy. Sure, we can find something that works for us and for the county and for the public. And unfortunately, up until the day of the rollout, the response from the county was, you know, don't worry, we will, you know, bargain impacts over this with SEMA prior to implementing anything. And obviously that didn't happen, right? The policy was just rolled out, implemented in day one. You know, labor relations did meet with SEMA and has met with other unions, but has not, well, at least as of, you know, I would say kind of a week or two after implementation, you know, wasn't engaging in good faith, hadn't responded to information requests, and kind of confusingly, in the summary response email that SEMA sent to labor following that meeting, just responded a week later saying, you know, well, we're going to proceed because SEMA's not identified any impacts or made any proposals or made any information requests, et cetera, which was kind of baffling because it was directly in response to the email Zeb had sent summarizing the meeting that we just had, right? So it was just, you know, clearly just not an attempt to try to meet in good faith with any of the unions. So that was the reason we landed on filing a PERB charge with the county. This just unfortunately kind of echoes similar to the process that we had with the telework policy, where, you know, SEMA was proactively trying to reach out, trying to work on a policy for a year for a post-COVID return to the workplace, right? and the county just, rebuffed all attempts to do that until they kind of last minute put a slipshod policy together and then try to roll it out quickly, right? So what does the PERB charge mean, right? So like I said, the goal of the PERB charge is not to stop the county from putting a vaccine mandate policy in effect. Rather, it's to, one, hopefully have them cease and desist implementation, and then meet and confer or bargain impacts in good faith with SEMA prior to implementation. That being said, the policy is in effect right now, right? This doesn't have, any kind of immediate injunctive relief, right, where the county's ordered to pause as a result of the SEMA has requested an expedited hearing from PERB, but we have to imagine that there are, quite a number of, other public sector entities filing, charges with PERB right now, similarly requesting expedited hearings. So at least right now, we can't anticipate what that's going to mean. Normally, that means you'll have a quick turnaround time in a matter of, weeks or a month. You'd expect to hear a response back. However, that may not be the case right now. Just being realistic. However, the goal is to have PERB weigh in that yes, the county did in fact violate MMVA and recent PERB rulings in the way they rolled this policy out. By the time that gets there, who knows where we'll be with current implementation of the policy. However, SEMA staff and executive board, felt strongly that this was a step we needed to take to ensure the county doesn't continue to, take union rights only as an afterthought in deciding their policies and moving forward, right? So we'll have updates for folks as that proceeds. We did file this case by ourselves. It's just SEMA filing it. There are other unions that have been discussing filing PERB charges or maybe considering it. We'll see if they do as well. But it's not necessary for this case and this charge to go forward. So I'll pause right there, and then we'll talk a little bit more about, separate from the PERB charge, where we are with the vaccine mandate rollout and policy. But first, I'll pause and ask for any questions.
And we have hit the 50-person limit, so please do put your questions labeled to everybody if possible. If it must remain private, address them to Adam or I, and we can read them out. But I don't see any right now, so I think you're good to move on.
Okay, great. So with our vaccine mandate policy now, as of today, everyone should be in compliance with the policy. The fact that we filed this PERB charge does not exempt folks from needing to comply with the policy that the county's put into effect, which means that as of now, everyone needs to have either submitted an attestation, right, that you have gotten vaccinated for COVID, that you're scheduled for your initial vaccine shot or a second vaccine shot if you're partway through your course, or that you've submitted an exemption request, right, either a religious or medical exemption. Now you don't need to have heard back on those exemptions yet, and most folks won't have heard back yet. All that's necessary is that you have submitted it. What we've heard back from the county, from Dr. Smith in our last meeting with him, I want to say, is that we were somewhere on the order of, I think it was north of 600 exemption requests had come in. Do you recall that exact number, Zeb? I think you just said north.
I don't.
600.
It was just north of 600, 620, yeah. Let's say, something like that.
Yeah, and we'll imagine that's going to continue to rise somewhat. However, we've also seen a number of folks. We just had someone say in chat for folks on the phone that it's up to 800 now. Yeah, so we'll expect that number continue to rise a little bit, just based on what we know the total unvaccinated number in the county is thus far. You're definitely welcome to reach out to your rep, either myself or Zeb, for any advice on the exemption process that you're looking for. As of right now, we don't have many folks that have been scheduled for kind of individual meetings in that process. It'll remain to be seen just kind of how busy that gets on our end, if that's something that either Zeb and I are able to attend with members on an individual basis, though we'll certainly try to. It's gonna depend on numbers. And I think we're hearing just the general tenor, and to kind of set expectations from folks, just from what we're hearing from senior leadership in the county. I expect it to be reasonably difficult for folks to qualify for exemptions, right? And we're hearing this from members as well, kind of coming back with the questions that they may have been asked thus far as a result of the vaccine mandate. It was definitely a possibility as to what this policy looks like, that it was, a fairly wide gate, easy to qualify for an exemption, or the county could apply a higher level of rigor. And it seems like there's definitely going to be a higher level of rigor. At the same time, I've had probably a dozen conversations with members by this point who, have said they were thinking they were going to be able to file a request for medical accommodation because they have, a particular, I'm, frequently allergic to vaccines, I have MS, whatever it may be, some particular issue, and that their personal GPs have said they're concerned about this, what could happen to their medical license if they write vaccine exemption notices for their patients, and have advised them that they're not going to be comfortable to do that. And in one case, one of our folks was told, just bring an EpiPen with you when you go to get vaccinated. So we're seeing that this vast majority of notes that have been put in thus far for exemptions are on the religious side. That being said, I think my personal opinion, my guess on where this ends up, is that, similar to how there was a cottage industry, if folks remember, 9-10 years ago when medical cannabis law was passed in California, there's kind of a cottage industry on writing those kind of notes for people. I wouldn't be surprised if that same sort of thing pops up, and the county's then gotta grapple with that. And we'll see how they'll respond if that happens. But again, as a reminder, folks need to either be in compliance with the policy, as far as getting vaccinated now, or you need to have submitted an exemption. You don't need to have heard back on the exemption, but you need to have at least submitted it. And if you're looking for individual help on those questions, you're welcome to reach out to your reps. Last point on this, and something we're pushing with labor relations and county executives, is that when we get to the point that folks are getting separated for non-compliance with the policy, which we know is going to be an inevitability, we don't know what those numbers are going to be, which is part of SEMA's frustration individually, right? That the county's made no effort to try to identify how many folks they expect to have attrit out as a result of this. But regardless, we're going to end up there. And our ask of the county and labor relations is that those meetings be handled either entirely by labor relations staff, or that labor relations staff are available to sit in at any meeting requested by a SEMA manager, who's going to need to be, labor has since sent out, the progressive kind of discipline timeline and packet for folks to follow through on this, which will eventually end in termination, right? If folks continue to be non-compliant. But I would say we would expect these meetings to be, reasonably difficult to handle for a couple of reasons. One, a significant number of them are very likely to end up in litigation, whether on an individual level or some sort of class action in the future, right? And secondarily, the best response for an individual being separated from the county for being non-compliant with the policy will be to continue to insist they're not being, terminated because they're non-compliant with the policy, but rather because the county or their manager just didn't believe their sincerely held religious belief or medical exemption issue or whatever it may have been, right? So I think we expect they're going to be difficult meetings, and the goal to reducing legal liability in these cases is to ensure uniformity of how folks are treated. And the only way to ensure that is to have a centralized manner in which they're handled, right? Rather than put folks on the front line and ask them, we wrote this 10-step how-to for you, so, best of luck following it. And we expect this to end up in litigation anyway. So that's where we're at with the vaccine mandate. We'll have more updates on the perp charge as time goes forward. Zeb, anything you want to add?
Yeah, just a few comments as well, so people understand. And I put this in chat. It always bears repeating. I don't want there to be any confusion. SEMA is pro-vaccine. We do have members, I'm sure there are members on the call that have put in for exemptions, or that their rights need to be honored through this process. So that's why we are filing the PERB charge. Filed, not filing. That's why we filed the PERB charge. That's why we're taking the positions we are. Also, our union rights need to be preserved. And you're going to see more on that when we're talking about the PERB charge that we have one. And in that discussion, we're also going to be talking about a PERB charge that's being filed in the assessor's office in the process of being filed. And those are also to preserve our members' rights And in that circumstance, and in the circumstance we're going to review, reverse specific behaviors. In this circumstance, it's to honor the process and make sure that our members, you all, many of you are supervisors and managers. So you're the ones who are going to be having to have these conversations with people who are not complying with the mandate. I think the rollout has been challenging. We have some people as well that are probably in the RA office or EO office. That's challenging as you all have to handle the subsequent complaints or accommodations. And the rollout, I think, has been pretty sloppy. This is me speaking. I'm not speaking on behalf of specific people. I think the rollout has been sloppy, and that's caused some challenges generically for supervisors and staff as they are at our level, at the SEMA level, as they're trying to roll this out. And it all could have been avoided, right? With a more deliberate and thoughtful engagement with both the labor partners, but also just generally managers and supervisors throughout the county.
Yeah, and as we're seeing, other nearby municipalities continue to grapple with this, we see that Santa Clara has really kind of been, substantially the most aggressive on this, saying that, we have this emergency situation and this needs to be implemented and rolled out, and we don't have time to, respect labor rights, meet and confer, consider anything else. But we're seeing Santa Cruz, for example, not put a mandate similar to Santa Clara in effect. They're allowing folks to continue to get tested on a frequent basis instead, which also just seems it allows them to just say there are no exemptions then, right? Because it's technically not a mandate. So I imagine they'll have a much smoother rollout of that policy than we're having. We're seeing, for example, Alameda have a timeline kind of pushed back to October, so that they have time to follow through the appropriate process with their union. So this is not this is kind of the most aggressive path that we've seen for nearby employers that Santa Clara has taken for whatever reason. And based on the rollout, it doesn't, seems like this was a poorly considered plan by kind of a small number of people, that this was the direction things needed to go. So that. And
one thing that's a little bit of inside baseball, but that is important for you all to recognize that Adam and I and the board are paying close attention to. At the Board of Supervisors level, this policy was explained to the Board of Supervisors as, quote, an administrative policy. And therefore, the county did not have to engage in bargaining with the unions. So this leaves wide open, anything could be declared an administrative policy. This is not spoken to in the law, the term administrative policy, MMBA, Myers-Millis-Brown Act. So just claiming that something is an administrative policy and therefore you do not have to engage in bargaining is a pretty bad red line to set. And it's unfortunate that it got set on this issue, which is such a hot button issue, right? It would have been much better if it was set on like, oh, we need background investigations required for all incumbent parks trails people, and you're kind of like, well, why'd you pick that code? And then great, then we would normally meet and confer about it. And it wouldn't just be, hi, I'm declaring this an administrative policy. We don't have to meet with anybody about this. It's effective tomorrow. So that's something where your staff and board are also looking out for your broader rights as well.
And we'll be continuing to, try to push and educate the board on this topic. For folks who were in the board's first meeting back 2 weeks ago, you would have seen some SEMA folks speaking at that meeting. Myself, Zeb, and Donna were there. We had some interest from the board and willingness to have, further conversations after that. So we'll see if anything changes at that level. But as well, just for anyone who didn't note the timeline and some more inside baseball, there was a deliberate rollout of this policy while the board was still on recess, right? So the board did not have a chance to weigh in on this. It wasn't agendized for discussion upon the board's return. Right. This is administration saying this is our decision, this is our discretion, and this is the direction that we as administration have decided to go, without board input effectively. Right. Okay. Well, let's move on to the next one we have here. So we have telework. Why don't we hit just for the thematic continuation? Why don't you talk about the PERB issue at the court, Seb, while we're still talking about PERB?
Sure. So let me lead this with PERB, Public Employee Relations Board, is where we can appeal things like unfair labor practices or violations of the Myers-Millis-Brown Act and get hopefully rapid rulings from PERB, right? Which this is a state entity. So California has its own PERB. Every state has a variant of this body. And in this circumstance, we filed a PERB charge against our sister employer, the Court of Santa Clara, Superior Court of Santa Clara. And this is particularly a particularly strong win for a variety of reasons. And then I'll talk about briefly what those reasons are, why it's important to all of you, and then what we're doing right now in terms of PERB charge. In fact, House Counsel just called me while we're on this call about the PERB charge we're currently filing in the assessor's office. So what happened is a member of ours was demoted unjustly. And I presented the case on this member's behalf. The hearing officer found that this was in no way a demotion, but should be a letter of reprimand. So think about the daylight between that. Demotion is the second most serious thing other than termination. Hearing officer hears the case, says this is no more than a letter of reprimand. I'm ordering that this be reduced to a letter of reprimand. The CEO of the court overturns that and says, no, I'm disregarding the hearing officer's finding and demoting this person. Why did it happen? Because there was disagreement with a particular judicial personality. So one of our members ran afoul of a judicial personality. That judge jumped up and down to administration. Administration honored that and demoted our member. We won, got the member's job back, got them some back pay. We ended up having to go to arbitration, legal fees paid for by our parent union, OE3. Great, we win that, fine. So what happens? The person comes back into the workplace and the employer says, welcome back. I know you're the director of this department. SEMA represents some directors, as you know, but we've decided to make 2 directors of this department. First time in court history. We're putting you on a different floor in a different office, PS with no windows, and you have no staff. So you're a director of nobody, right? So we take this to PERB, win, and PERB says, get out of here. You can't do this. Like, you've got to restore this person to the. Now, it just so happened that the other co-director, if you will, that maintained control over the unit retired. So our member ended up getting that position back. So PERB was a little bit late to the party on this, but they ruled that they had to give the person their job back, their actual job, right? Not a fake job, a do-nothing job. And also ruled that the court was in violation, engaged in retaliation, and has to, this is the key, has to post a 30-day notice electronically and in all public venues, so read outside every courtroom, that says the court engaged in discriminatory and retaliatory behavior against SEMA member Joe Blow, and we'll name the person. We'll do an article about this later that our member will allow and pre-read. And this is a huge embarrassment and black eye to the court, right? Also, it's a key victory because many times organizations don't like, and lawyers for that matter, don't like to take cases or go against a court because they will in the future have cases before that court. So it was a really great victory on this person's behalf. It's a big black eye to the court, and it emboldens our other court members to feel like, hey, look, I can come forward with legitimate complaints and I might win, right? It's not just the court gets to step on my neck and I can't do anything. And I say this all the time. Generically, Santa Clara County, the Superior Court, are benevolent employers. Sure, we clash with them on a lot of issues, especially recently over certain behaviors. But generically, they're trying to pay people. They're getting people, healthcare and administering policies reasonably competently. Sure, we fight about lots of them, especially recently. But generically, it's a reasonable place to work and pretty good. But it's when they really doubled, tripled down on situations like this that we got to give them a bloody nose. We did. It's good for everybody at the staff level in the court. And this feeds into the PERB charge that we're filing as well in the assessor's office. Again, I'm not going to get into the details on this call because it hasn't been filed yet, but the purpose of this is to preserve people's rights, make sure that our members understand that if they stick their head up for something legitimate, which completely happened at the assessor's office, they're not going to be retaliated against. And in this circumstance, in my heart, I believe 100% that they were, that people who brought forth bona fide issues were singled out and targeted, and the evidence will speak for itself, that it just is so apparent to any reasonable third party that looks at it that the only explanation in my mind is retaliatory behavior for union activity. So
And we
we'll
have,
see that. Go ahead.
and sorry, and just to jump in, folks, for example, I see we have some folks from our EO office on the call, and people who have been through investigations will know this. Proving retaliation, even where it might be bona fide, is one of the most difficult things to establish, because in some sense it gets to intent and it gets to mindset with which an action is taken. But like Zeb said, there's really just overwhelming evidence in this particular case. And part of what our goal is when we file charges like this, right, is to ensure that we don't have to file charges again in the future, right? We have an overwhelmingly winning record against the county and against the court, whether it's in arbitration, whether it's with PERB, whether it's in the personnel board. I don't know that in Zeb's years here, have we ever lost an arbitration, Zeb, in the years you've been here? Or PERB charge?
Arbitration, no. Personnel board, yes.
Personnel board, yes.
Yeah.
Yes. Though not the majority of those by any stretch. But the goal is that when we come forward in the future and say, hey, let's resolve this issue because we're willing to take it to arbitration, we're willing to take it to PERB, right? If we can't get a resolution that the county knows, one, that's bona fide, and two, seems very likely to prevail, because we don't take bad cases. There's no point taking a bad case to arbitration or to PERB, because that just undercuts the implied threat that you can do it again in the future, and prevail, because maybe you've just got this one wrong. So that's part of the behavior that we hope to shape in the future, and why it's important to take strong cases when we have them, as we do in these cases.
Yep. And so do you want to cycle back to telework perhaps?
Yeah.
And let me just put it, we're dealing with a lot of weighty issues right now, right? We're talking about COVID and the mandate and PERB charges and everything. So let me just lighten it for a second. This is not an agendized topic. I want to really thank everyone who came out to the 5-10K run. Was it this past 2 weekends ago? And also the SEMA members that showed up to the Ellenberg campaign kickoff. It's great for us to get our face out there. There were a lot of executives, community members, board of supervisors members out there. And I feel like the people who attended seemed to really enjoy it too. So I would encourage you all, we had 100 tickets. We certainly used the majority of them. I don't know quite how many attendees we had. It was a nice opportunity to see people with their SEMA shirts, SEMA masks. People ran, people walked. You do it at your own pace, but it was just nice to get together and see everyone. We got some great photos too. We're going to be posting. So as we can kind of engage more in person, for those of you that are comfortable doing that, I really encourage you to come out and participate. So thanks to everyone who did that. Okay, so let's move on to telework. Do you want me to take point on that one, Adam, or do you want to?
Why don't you go ahead and take it?
Okay, sure. So telework policy, as you know, we have a new rollout that has been occurring. I'm going to post some things, just some bullet points in chat about the telework policy here. Generally, there's been more telework post return to office. I know that's not the experience for some people on this call. There are particular departments that stand out as having significantly less. Good standout examples are the assessor's office and 911 county comm. Both of these departments stated, but for the work from home mandate, the stay at home mandate, we never would have approved telework for anybody, period, anyway, right? So, however, we've had to. So we did do it during the pandemic. Now that pandemic's still going, right, as we're seeing with the numbers, but now that people are returning to the office, we're requiring folks to come back. So generally in offices, we're seeing significant upticks in telework. SSA, we're seeing 3-4 days for 4 classifications that it makes sense. And I'll talk about what that means in a moment. We're also seeing, yes, it does. I'll address that specifically in a moment, Mary Beth. Sorry, now I lost my train of thought. Oh, we're seeing more telework generically. As I mentioned, there are some outlier departments where we're seeing the same 0% or very low percent that was offered ahead of time. Most departments have been satisfied with what I'm characterizing as knowledge workers continuing to work remotely 2, 3, 4 days a week. Okay. And the policy allows that. The new policy allows the department at the departmental level to make a decision. So Mary Beth asks in chat, can you address whether or not the county telework policy allows for 100%? It does. It could be whatever the department and the manager and the employee decide that it should be. It's not a right, it's privilege, right? So you could put in for 5 days a week, for example, and it could be approved. And we've seen that in some select circumstances, certainly not universally. I think generically we're seeing 2 or 3 days seems to be kind of the sweet spot for classifications that it makes sense. So I keep mentioning that term. What do I mean by that? Well, if you're doing bedside nursing or you're building parks trails, you just can't do that remotely, right? It's very, very difficult to do that. Maybe 1 day a week or 1 day a pay period, you've got like a bunch of payroll or orders or requisitions or something you need to do. And maybe it's your quote unquote office day, right? That you might be able to do. But if you really need to be walking the floors to inspect that janitorial work has taken place or direct staff, you need to make sure that the trail crews or the roads are being paved or whatever it is. You really can't do that work remotely. It doesn't lend itself. That type of work doesn't lend itself. What does? Boy, does medical billing lend itself to that. Wow, does most of the IT work lend itself to that. 4 or 5 days a week, it lends itself to that, right? Client-facing things, less so. So it's a real case-by-case situation. So to Mary Beth's question, yes, it allows for that. Does it work for your particular role? I don't know, right? We'd have to talk about it. And that's what we're doing. So behavioral health, for example, and this is a good, I don't know if I haven't looked to see if we have some members from behavioral health, we probably do. Behavioral health is a good example. Their department came out and said, if you're a supervisor, we want you in the office 100% of the time, maybe 1 day a week telework. Everybody else can apply for 2 days telework. I said week, 1 day a week telework. Everybody else, 2 days max. Now, the information that I've received so far, the department's being a little bit shifty on this. So what they're doing is they're saying, oh, there's not a hard ban on anything more than 2 days a week telework. But what's happening is people who put in 3 or 4 days, their supervisor or manager or director, depending on the size of their unit, rolls over to their desk and says, hey, I got thank you so much, Joe, for your telework application. I got it. I'd love to approve it, but I really need you to put down 2 days a week and then I'll approve it. So the member, not necessarily knowing the process or just wanting to get rolling on telework right away, whites it out. Nobody uses whiteout anymore. Goes into their Word document and edits it and sends it out again with the 2 days. Now this does a couple things. One is it means that we don't get involved as a union to say, hey, you denied the telework. You got to explain what the business reasons are to deny it. And 2, it means that now the department can claim a nearly 100% telework approval rate, right? So if you just look at the numbers, instead of them denying, let's say 50% off the jump and then people resubmitting and then it getting approved, it's just like, we don't have any telework problem. We've approved 95% of all people that have put in. So again, I applaud that even 2 days a week is being allowed. That's probably a stretch, but there are many classifications at behavioral health and many others, I'm not just picking on behavioral health, where boy, more than two days a week sure makes sense for a great number of our classifications over there. And we have been getting some receptive conversations and a few people approved for 3 days a week at behavioral health because I've gotten involved and the members have stood up. But don't be shy about that. Reach out to Adam or myself and we'll get involved and we'll make sure that maybe there's a business reason, but where there's not, that they really do try to up that daily allotment.
Yeah, and I would say where we've had kind of good success overall is we've had a number of departments that came out with sub 2 day telework, and I'd say in almost every case where it's a reasonable classification to be teleworking, we've been able to get folks up to at least 2 days a week of telework as kind of the minimum. And if folks will recall, kind of going back 2 months, that was kind of what we'd said is the minimum, is we want to see either more telework than you had pre-COVID. So if you were at 2 days pre-COVID, then we want to see more than that, or at a minimum 2 days of telework. And I think the county's been pretty reasonable at getting there. And departments that were doing none or 1 day, we've been pretty successful at getting them up. Getting over that is something we're definitely looking to push for. But at this point, I think to see a large shift kind of county-wide, there's going to need to be, really a push, unfortunately, likely by the Board of Supervisors or because at just the senior level within administration, we can see, for example, and I'd say that, SEMA has a great relationship with Miguel, for example, but we know Miguel has what I would characterize as kind of outmoded ideas about what work looks like in 2021. And that his departments, for example, are some of the ones in the CEO's office that have had, a lot of trouble with telework. And that kind of where we're at now is the consensus opinion of where the county wants to be, right, from the senior leadership level. So if there's going to be a shift from that, then it'll likely need to get pushed by the board. We've heard at recent board hearings, board members making some kind of positive sounds with this and kind of pushing and questioning the county on how we ended up here. And the line that we've particularly been pushing and what we didn't talk about with the vaccine, mandate rollout is we've really been trying to cast, the vaccine mandate rollout in the context of this is a perfect opportunity to be doing more telework than we are right now, right? Going back to May when the county set kind of the return to work timeline for June, July for most departments. Frankly, we didn't have Delta variant yet, right? It seemed like the COVID thing was winding down. We're all looking forward to get back to our regular lives. And now we know that's just not where we're at, right? So we brought people back into the office, then we reinstituted mask mandates. Now we're mandating the vaccine. And there's been no pause to consider that, hey, we had a lot of departments that were teleworking at greater than 100% productivity during the lockdown. Maybe there's no good reason to have them here right now, right? If we're increasing some level of risk. And, the rhetoric we've had is, look, this makes it not just a safer workplace for employees, but for the public as well, right? Do you want to be, if you've got, surgery scheduled at VMC, would you like to think that just the essential medical staff are there? Or would you like there to be 1,000 miscellaneous, finance, medical billers, et cetera, people that are on their computers and on their phones all day, but who may have brought in, a breakthrough case of Delta variant into the hospital to be present? Well, obviously the former, right? And the same holds true if you're at, SSA seeing clients or DTAC or whatever it may be, anywhere the public's coming, right? We've heard some positive sounds from the board yet. As folks work off negotiations, we never say, what an individual board personality, said to SEMA. We want them to know they can speak in confidence. But we've heard, for example, some good comments publicly in board session from Ellenberg and from Chavez on this topic. So hopefully it's something we're continuing to push. We're continuing to reach out and do white papers on. Hopefully we'll be willing to see some board action on increasing telework in the coming months. But that's really where we'll need to push to see any kind of radical change other than just, as Zeb's kind of saying, kind of picking around the edges, seeing where we can get, 1 or 2 more days of telework at the individual level. If we want to see any shift in policy, that's where it needs to happen. And that, at least as of right now, what we've heard from all our executive partners is that there's been no shift from Jeff or Miguel that when you're approving telework, you are not to take into account anything to do with COVID or Delta variant or whatnot. That's not to be a consideration, right? And for example, if we were just able to get that overturned by direction, that would allow departments to take that into account as a reason to send folks back out full time where appropriate, right? And where productivity can be maintained at a high level. So we're continuing to push on this, and hopefully we'll have good news for folks in the coming months.
And it's a longer term legislative priority, but we will be focusing on it in probably 5 weeks. The county has agreed to meet with us to discuss a new telework policy, as Adam mentioned, but just agreeing to talk about something until we have something concrete to present, it's just a lot of talk. So we're hopeful, but we'll see. And we're building support on the Board of Supervisors, who's generically supportive of expanded telework.
We have a question.
Address, Bhutai, your question. And we would handle this. So let me read the question for everyone in case there are people attending by phone. Will the determination for telework request be a case-by-case basis? Can executives determine the specific days of a week employees can telework? The answer to that is yes. So they can say, for example, the boss, the director of the department says, I don't want anyone teleworking on Wednesdays because that's when our all staff meeting is, or I don't want anyone teleworking on Mondays because that's the busiest day, or whatever. They don't even need a reason. They can just say nobody teleworks on Mondays. They should have a reason, but they don't need one. What is SEMA's approach when managers approves the telework request and executives override it? So we treat this very similarly to a person to if you put in your own request and it was denied. In this circumstance, you the boss of the unit, right, are saying, this worker can be fine 3 days a week, and the executive says no, they can't. I want them there 5 days or whatever they counter with and override you. So we would still we don't want to get involved. We are happy to get involved if you want us to be. So that's where we'd go to the boss, the director, or whoever it is, executive in this case, and say, look, our member or applicant, it might not even be our member, believes they can effectively work 3 days a week. The supervisor, who knows best, thinks they can work 3 days a week, and you're saying they can't. Why? We support our supervisor, our manager, in their exercise of their judgment, running their own unit. So what's the problem here? So we treat it in a very similar way, as we would to just a member saying my request got denied, right? You have those rights too. Chris, go ahead.
Oh, sorry, I was going to get the next question.
Yeah, go. Why don't you? Hey, Adam, how about you? I'm gonna hop on my phone and start moving to my next meeting here.
Okay.
Thank you.
So, a question from Martin here. Can department leadership say that they require you in the office 3 days a week without providing a reason? So I would say we have a lot of departments, right, who are saying that we're allowing 2 days of telework, we're allowing 3 days of telework. Some of the shift on that is where departments are saying, putting it kind of other side, as opposed to saying we're allowing 2 or 3 days of telework, we're being a 2 or 3 day a week in the office department, right? And that pushes, on people who might work a 3/12 schedule or a 4/10 schedule or whatever it may be, right? So that's something that, yeah, we're seeing across the county. So there's not any reason they can't say that. And I would imagine in cases where we ask, I know in the cases where we push on this, that the reason is that, they're saying we need people here on Wednesday, Thursday, and Friday, because those are days that we have, high traffic from the public, or we have our all staff meetings. So broadly, yes, they're allowed to. It remains the case that telework under the current policy is discretionary, right? On the department side, there's no guaranteed mandatory minimum, just like there's no maximum, right? There's no minimum nor maximum telework under the policy. That is something we're going to be looking to change, right? When we move forward with, like Zeb said, we have a commitment from the county 6 weeks down the line or so to kind of reopen and look at the telework policy again to see how we can improve it. Will be to include things like that, right? That take into account alternate work schedules so that their folks that are on them aren't punished with regard to telework. Right. Well, if we had some more questions here. So question here from Griselda saying, if the executive level is saying that the minimum office requirement of 1 full day for SEMA members, can that be defined as an 8-hour day, given that we are salaried? I guess I'm not sure exactly what you're asking. Are you saying that someone, so say you're on a 4/10 schedule, can I then just work 8 hours and telework the last 2 hours of my day?
This is Griselda. So like if there's an alternate work hour request, and let's say the alternate work hour request is the individual works either 4 hours or 6 hours on Monday based on their alternate work hours proposal, but there's an ask that it be minimum of a full day, quantifying it as an 8-hour day.
Gotcha. So they're telling you that the day you need to be there is a day where you're working a full day there. Look, so there's nothing saying that they can't do that because they have discretion over approving telework. The possible way you'd have to address that would be if the reason you're working a shorter day is for some kind of medical accommodation. You could argue being treated differently as a result of the accommodation. But ultimately in the policy, they have the discretion to either approve or deny, and they can say, I'm going to deny this one, but if you put in the other day, then I can't approve it. kind of like Zeb said before, right? Kind of asking you to put in the request that they will approve, and they have the right to deny the other ones. But that seems like a pretty unreasonable request. But if you're only being required to be there 1 day a week, I would say that's substantially better than most folks in SEMA situation they're in right now. So if the only caveat to getting 4 days a week of telework is that the day you're there, they want you to be there for a full day, I would say the department hasn't taken an unreasonable position given where most of the county's at right now. Does that make sense, Griselda?
Yeah, sorry, I was trying to unmute.
Okay.
Got
No
it.
Okay, well, we got about 12 minutes left. I see we have more questions. I'll come back and get them at the end, but I do want to hit the last couple items before we hit 12 o'clock. So I'll return to the rest of the questions at the end.
But prior to rolling into GARE, do you want me to just give a quick update on the OE3 election third business rep, or do you want to hit GARE first?
Yeah, why don't you hit the election real quick?
Okay, so the vote count occurred yesterday afternoon, and it was formally closed at about 4:30. And the so-called gold ticket prevailed, which was the recommendation or endorsement, I should say, of the SEMA e-board. Thank you to everybody who voted. This means that we'll have stability in the relationship with our parent union, OE3. Not that we knew for sure there would be instability with the other group, but we know that this group understands well the intricacies of public employment and especially the professional nature of the SEMA unit and the semi-autonomy we have. So great job. Thank you for voting. I'm assuming you guys voted for them, but I don't know that. Thank you for voting regardless, whatever way you voted. It's important to participate in our union democracy. And fortunately, a slate that's very easy to work with for us did get reelected. So thank you on that. With regards to the third business rep, we received, thankfully, a fair number of applications for the reposting. As a recap, we did offer a position to a very good candidate in the last cycle. Unfortunately, she did not want to relocate from Sacramento, so it didn't work out. Now we have some new applicants, and we have identified 3 that we'll be interviewing. I hope we're going to set that up for next week for a preliminary interview, and then a subsequent interview with elements of your e-board so that we can get the best candidate that we can. So those are my updates. If there are any questions in chat, Adam, I can't see them, so please let me know.
Just on telework. So keep going. Thanks, Seb.
Yep, great.
So last item on the agenda here is on GARE and real teams. So I don't think we've discussed this at a combined site meeting yet. So depending on the department you're in, this may or may not be something that's been on your radar. So GARE is the Government Alliance on Racial Equity. And it's a group that's been doing training for public employers for a number of years now. We've had some departments that were sending their staff to get GARE training going back a few years already. And the real teams are a more recent development, specifically in the context of SSA. And we're sharing this info kind of as just a heads up and awareness of what was going on in SSA as something to kind of just keep track of and be aware of elsewhere, because I think what we would characterize it as it was an inartful rollout of kind of some of the GARE principles around having a more inclusive, less discriminatory workplace, which we're all in support of. But unfortunately, the rollout was definitely not ideal over an SSA. So what happened in SSA was they had folks who had gone through GARE training and were on the real teams. People who were part of that group were, effectively picked by executive leadership, right, to be a member on one of these teams. So it wasn't a meritorious process. And they were then given a seat on hiring panels. And it wasn't clearly communicated kind of what this person's role or purpose was on the hiring panel. But prior to leaving, the executive over some of these positions that they were SEMA directors hiring for positions, and prior to excusing themselves from the interview panel, the executive made it clear that they expected unanimity and consensus from this panel before moving folks forward. And what happened in one of these cases was the real teams member particularly disagreed with the choice of the rest of the group and of the hiring director and refused to move that person forward. And it at least felt like to our member that the
just as a correction, Adam, sorry, hiring manager, the director left the interview. Yeah.
Sorry, hiring
our folks, yeah.
Yeah, senior person in SSA, right? Senior person in SSA, and that it at least felt like to our members who were involved that the person's skin color may have been the particular issue that was standing in the way, right? So SEMA has had a couple meetings with SSA about this to address the concern, to say, hey, what's the role of the real teams folks who are going to be in on interview panels? How were they selected? Why were they there? And I would say of chief concern was the department's inability to answer what seemed like some basic questions from us. Things like, say I'm an applicant for a position in SSA and I ask who this real team member is on my interview panel, who in their title I know has the words racial equity. So what are you SSA going to tell the applicants about what this person's role is, such that you can convince them that that applicant's skin color is not being taken into account, right? I think we all know the employment process is the most frequent nexus of employment litigation that you all deal with, either as hiring managers or, I see some of our EO folks here, how frequently these things end up in discrimination allegations. So what can we do, SSA and DARE team folks, to ensure that we've not just created another nexus for employment litigation against our hiring managers with this process, right? And unfortunately, their response was, we're currently working on that with ESA. And so the thought would be, well, this is the kind of thing that you should have worked through before you implemented this policy, right? So SSA leadership stepped in and put the kibosh on it for now. And we're seeing, at least at other departments that I represent, for example, like VMC, I think we're seeing a much better rollout of this, where the folks with the focus on, racial equity and reducing discrimination on the hiring process, they've taken the training they've received and they're going through kind of the interview questions with a fine-tooth comb, trying to figure out how can we change the hiring practices to be less discriminatory. Maybe we send the questions out in advance, but specifically introducing people into the hiring panel, I think had a serious optics issue for a lot of our managers, right, who are doing hiring, because all of you who are hiring managers know that the county's hiring system is at least set up by intent to try to eliminate the possibility of discrimination, right? It's supposed to be a hiring system based on merit. It doesn't always live up to that, but the design is that it's intended to be based on merit, right? Meritorious. And that you as an individual manager can and frequently are, called in and questioned as a result of some complaint to say, hey, prove to me that, you weren't discriminatory in how you conducted this hiring process, right? So that expectation is set on you to prove that you're, being meritorious and non-discriminatory. But then the county's introduced an element into that hiring process that is expressly not meritorious, because it's someone who is individually selected by an executive to go get particular training and then get placed on a hiring panel, seats which are generally coveted by, people like more involved in the hiring decisions. So everyone would have liked one of these spots, but wasn't afforded the opportunity. And unfortunately, there was, I think, not an understanding or recognition, at least when we raised that was a concern. That being said, senior executive leadership at SSA kind of put a pause on this. They're pausing and reevaluating, and we're hoping to see kind of a more thoughtful rollout of kind of this race equity work, as we're seeing in departments that are doing it better, I would say. And I would look at HHS, who seem to have a better handle on this, but something to be aware of if it's happening in your areas, if it's causing issues with hiring. In other cases, we've heard, for example, hiring's been paused for weeks or months because someone from Real Teams wasn't available. We all know how hard it is to hire anyway right now. So we want to ensure that, whatever's happening on this with departments, it's helpful and not a hindrance. So keeping everyone informed on that.
And
I will go
I
back.
just want to add a quick point on that. I know we're running short on time. Is that, this was raised to us by SEMA members, right? Imagine you walk into a hiring panel and there's someone unexpected on the team that has this authority. You'd be shocked. That's one of the reasons it was raised. The other reason is why it's so sensitive is it creates another opportunity for an EO nexus, as Adam was pointing out. We've been even asked at SEMA to remove from our membership form where people put their ethnic derivation or gender. And we've been asked to remove that because the county said, look, someone can raise a complaint that the week after they submitted their union form and declared a particular ethnicity, something happened to them at work, and they can cite that as the nexus. And so we did that. We've complied with that. But it was something that it just seems unusual to add then another opportunity for someone to file a complaint.
Absolutely. Well, happy to take any questions on that, but if not, I'll go back and start addressing some of the telework questions that we had here. So I have a question saying, I'm the unit manager and don't have any issue with approving staff for 3 to 4 days a week, but our executive makes me approve only 1 day on the form where I put my comments. Can we work with SEMA? Can we work with SEMA to get more telework days? Yes, absolutely. Please reach out to either myself or Zeb as is appropriate. And this is an example, right, where the county's got a little bit of a kind of Mott and Bailey tactic going here with regard to telework, right? Because they'll hold the policy out there, and the policy says you're allowed to have up to full-time telework, and there's no prohibition against that. But then from the executive level, we'll see kind of direction setting expectations for how much will be approved, right? And then the county pulls that back and says, well, this is entirely discretionary, and we're able to give that direction if we want to, right? So it's unfortunately a little bit difficult to grapple with, but we're happy to get involved, and we're happy to try and assist on that.
I'm just arriving at my next meeting, so thank you, everybody. Thanks, Adam, so much. Be well.
Yep. We have a question here from Isra asking, when asked how these approvals will be reevaluated monthly, I didn't get a clear answer from executive leadership. So the policy doesn't require approvals to be reevaluated on a monthly basis. Your department may have set that expectation, and they're making a lot of work for themselves to do that, but it's not part of the policy. That's something that I guess your area in the CEO's office may have put in place. There was a question here. I think this was in the context of Zeb saying how SEMA folks are being asked to resubmit their approvals as something that will be approved rather than have denials come forward. Stefan's asking, do you want to see partial approval reported separately from approvals or rejection? I don't know that right now that's going to be helpful, Stefan. We've put out probably 3 or 4 surveys in the last 6 months specifically about telework. We'll likely have one more at some point in the near future, and that may be a question. But it's frankly just very obvious when we see a department where every single person is approved for example, 2 days or less of telework, that it's not an option to get approved for more, right? So I mean, I think it's clear when you just look at what people are approved for, what the de facto policy from a department may be, right? Even if it's not a written policy. So I don't know that we need that at this point, but we'll definitely have a survey in the near future about how telework has rolled out in the last couple months. We got a question about the real teams. Let me read this real quick. Sorry, it's a long one. So there's an initial observation that the real teams folks were handpicked by executive staff. Yes, that's correct. And when we raised that point, the response from SSA leadership was, well, then we'll open it up to everyone. And if every SEMA person wants to be a real team member, then we're happy to have them. which is an acceptable response, I guess, to us raising the concern. So for anyone in SSA who wants to join Mule Teams, they've committed that it's open to anybody who wants to join now. But yes, the initial rollout was obviously biased by folks who were hand selected, and all of them. Yeah. Yeah. So then just kind of some initial additional observation on how this introduces bias into the process. What we're hoping to try and make less biased. Yes, that's absolutely the point, and that's the point that we've tried to make, is that, you know, from SEMA's perspective, we really don't need another reason for folks to have discrimination complaints filed against them. For example, I would say I've probably been in 2 or 3 cases representing folks in discrimination complaints in the last few months who are being alleged to have retaliated against one of their employees because the employee was participating in GARE or Real Teams. And I can just say personally, I would say I'm confident that wasn't the case in any of those instances. They'll be investigated by the appropriate people. But yes, it's just an example of how this process and how folks getting selected in a non-meritorious way to participate can engender additional complaints that folks in SEMA have to then deal with and respond to. So I agree. Well said. Okay, well, I think I addressed all the questions we had in here. And speak of the devil, I have another, I gotta go represent a member on one of those discrimination complaints. So I'll have to leave folks here. For those folks who reached out specifically about questions, I got a few private ones on exemption questions or about telework. Please reach out to myself and Zeb, and I'll see, we'll get a response back soon. Okay. Thanks everyone. Take care and stay safe.